Hi, I'm Obi. I'm a legal practitioner qualified to practice in both Nigeria and the UK. I'm also a musician and recording artist. I help break down the business and legal side of the music industry so you don't get played. Now, suing a megastar might seem like a great payday, but if you don't have exactly what you think you own, then you might end up paying a $500,000 bill. Now, that's what happened to emPawa Music Africa, headed by Mr. Easy and the Nigerian producer Dera, when they decided to sue Bad Bunny over the track Ensenama Baila. Instead of getting the payday of $100 million, the whole case collapsed. In this episode, I'm going to break down what creators must do to keep their rights in order to avoid firing legal shots before you work out exactly who owns what in any musical composition or sound recording you may make. Now, filing a $100 million lawsuit is the easy part. Surviving the discovery procedure process is the hard part, where you're supposed to now produce the evidence in which you're relying on to prove your case. This is before trial. When the defense asked emPawa Africa, Mr. Easy's label, to show how they had exclusive ownership of the song in question. So in 2019, the producer Dera made this beat. Later on, the artist called Joe Boy worked with Dera and they produced the song Empty My Pockets. This is back in 2019. In 2022, Bad Bunny released a track called Ensenama Baila. Now, emPawa Africa accused Bad Bunny of stealing the song Empty My Pockets, saying essentially that they'd lifted the musical bed and most of the composition directly from the song. And then even during some of the live shows, that they would play the track as a backing track while Bad Bunny performed the song. However, Bad Bunny's team said, no, we did clear the song. We did clear the sample. We cleared it from Lakizo Entertainment. emPawa said, no. You could not have cleared it from Lakizo Entertainment because they didn't have the authority to do so. They don't own the song. We own the song exclusively. Therefore, whatever you did with Lakizo Entertainment has nothing to do with us. You have infringed on the copyright of our song, and we want at least $25 million per claim. There were 4 claims, and the claims were for the sound recording and composition of both the instrumental that was produced by Dera and the later track that was made by Dera with Joe Boy. So it's $25 million per claim, $100 million in total. Pay us and pay us now. So the defense say, okay, show us the evidence that you have exclusive ownership of that song, Empty My Pockets. Because as far as we're concerned, we did everything we were supposed to do. We got the clearance from Lakizo Entertainment, who say that they are co-owners of the song, but you're saying that you have exclusive ownership. Show us you have exclusive ownership. It would seem that under pressure of being asked to provide this evidence, Mr. Easy's lawyers withdrew from representation in January of 2026. They said there was a breakdown in the client-lawyer relationship. There was a failure to agree legal strategy. So there was a dilemma. In US law, a corporation has to be represented by a licensed attorney. So at that point, emPawa had no legal representation. The court then said to emPawa, listen, you guys need to go and get a licensed attorney because we've got a discovery hearing coming up in February and you guys need to be represented. A date was given for them to get this attorney, to appoint an attorney, and emPawa Africa did nothing. So following this, the court removed emPawa from the case because they had no representation. The only person left now was Dera. Now Dera is acting in his own capacity and is allowed to represent himself. On the day of the discovery hearing, no Dera. The court was like, where is this guy? Issued a motion compelling him to attend, to explain his absence. No attendance. Eventually, on 9th of March, the court just threw out the case on the basis that they had clearly abandoned the claim. There was nobody representing the matter anymore. And it was dismissed with prejudice, which means that the case can never be refiled again. Completely done. Case ended, finished, 9th of March. On the 23rd of March, though, Bad Bunny's lawyers filed a motion saying, wait, hold on, you can't take us to court, accuse us of copyright theft, drag us in the mud for, 3 years? Because remember, Mr. Easy raised this issue in 2023 very, very publicly. They decided not to take any action against Dera, saying that it was clear from the action that the whole strategy and the financing of the case came from emPawa Music Africa, not from Dera. Although I suspect it's because they probably don't think that Dera has the $500,000 to pay. I don't know if Dera's a millionaire, please let me know. But certainly they believe that the financing and strategy of the case all came from emPawa. So they shielded Dera from this motion to pay $500,000 and are facing emPawa Africa directly. Now, essentially what probably happened in this case was that there was no clear chain of title between Dera, Joe Boy, emPawa Africa, and Lakizo. Lakizo Entertainment had a distribution deal with emPawa Africa. Under that distribution deal, it seems that they were put down as co-authors, co-owners of that copyright. So when Bad Bunny's label did business with Lakizo Entertainment, they purchased for value goods title to use that sample in the song. So there's this case, Odo versus Reyes. Under US federal law, any co-owner of a copyright holds an independent right to grant a non-exclusive license without the consent of the other owners. And that's what happened. That's what Bad Bunny's lawyers were saying. We've been given clearance. Okay, if you say we didn't obtain it properly from Lakizo Entertainment, show us how you have exclusive ownership of that beat. And this is what Bad Bunny's lawyers relied on from the beginning, from the get-go. They said, look, we've got good title, we've got good permission. emPawa Africa were not disputing the fact that Lakizo were their distributors, but there was an issue in regards to how emPawa viewed the relationship with Lakizo. In the case like this, there should be an explicit term requiring mutual consent by all co-authors before any licensing agreements can be made. Afrobeat is now global currency. If you haven't got these things sorted out at home, it's going to follow you wherever you go. It will follow you to US, it will follow you to UK. You've got to understand who owns what. When we get into the studio, it's just vibes, you know? Nobody really understands what's happening. When the song makes a big splash and there are millions and billions of streams involved, all of a sudden, everybody's memory is different from what happened at that time. So the key is to get your splits, your agreements, all these things agreed before you leave the studio, before any streams are made. This case exposes the brutal reality of litigation. You have to get your house in order. You have to get your evidence in place. Because if the megastar decides to call your bluff and fight you in court and you don't win, and especially in a case like this where you run away altogether, you're going to end up facing a huge legal bill, because you just can't take somebody to court, make them run that expense and then run away as if nothing happened. And please remember, behind music is business. You need to know this so you don't get played.